Okay, so good evening, everyone. Karibuni. So today we are going to have Wakili Rodgers Mwangi presenting on data protection and the right to privacy in the digital space. So a few housekeeping rules. This meeting is only for 40 minutes. And the session is being recorded. Also, if you want to ask a question, kindly raise your hand. And if you are going to ask a question, and in the interest of time, keep your questions short and precise and go straight to the point. Don't beat around the bush. Go straight to the point. We don't have the luxury of time because this is the free 40-minute session that we have from Zoom in this Zoom platform. So we can't do an hour, we'll just do 40 minutes. Also, I'd like to introduce myself. My name is Angela Aching. I'm currently at the Kenya School of Law. I studied at JKUAT Karen, and yeah, I'm a lawyer and I'm a trainee advocate. So I'd also like to introduce the speaker of the day, Rodgers Mwangi. You can see him, Wakili Rodgers Mwangi. So he's a law graduate from UON. He's also the current president of the Digital Freelancers Association of Kenya. He's also the current male class rep of Class E, the 2021 batch. Yeah, so he holds all those and many more. Time won't allow us to explain further. So I'll proceed to make Rodgers a host so that he can be able to share his screen and be able to start the presentation. Thank you. So Rodgers, I'm making you a host. And
okay.
As I make you a host, also, you'll be adding people as they join.
Oh, as they are.
Yeah,
okay,
you'll be
no
adding people. Okay, so
okay.
I'll make you a host. Let me mute.
So thank you, Angie, for that wonderful introduction. I'm Rodgers Mwangi, an advocate trainee at the Kenya School of Law, also the president of the Kenya Digital Freelancers Association. And on the topic of today on Sharia Clinic, we'll be discussing data protection and the right to privacy in the digital space. So from data protection, basically we mean the protection of personal data. Maybe I could share my screen so that you guys can also see. Just a bit. Can you guys see my screen? Okay. So firstly, we'll embark with dealing with the right of privacy. So what is the right of privacy? The right of privacy is a fundamental right enshrined in numerous international human instruments. It is central to the protection of human dignity and forms the basis of a democratic society. Therefore, in regard to the digital space, it's about protecting information in the digital, having your own private sphere, whereby your information is free from arbitrary or state intervention, or also sharing without your personal consent. There is also law that has been developed in this regard, both international and domestic. The first landmark law in relation to the right of privacy in the digital space was the European Union GDPR. GDPR stands for General Data Protection Regulations. So once it was enacted in 2018, that was when we had model laws coming up from that. And the first one was in Africa, whereby regional bodies began to enact laws to protect protect personal data. In 2014, the African Union developed the Convention of Cybersecurity and Personal Data Protection. Also, as you remember, Africa is divided into various regional blocks, including COMESA, ECOWAS, and also the South African Development Community. So in 2010, the South African Development Community developed a model law on data protection. This was in 2013, but prior to that in 2010, the Economic Community of West African State, ECOWAS, had also enacted a supplementary act on personal data protection. The East African Community was the first one in 2008 to enact legislation, and all these were not legislation per se, but they were models so that they may guide the countries on how to develop a framework to protect data of their citizens. I'll share with you my write-up whereby I've listed laws here that deal with privacy and data protection. Now, when you go to the domestic laws and regulations related to privacy, in Kenya, we have Article 31, which is the supreme law and guides all other laws, which states that everyone has the right to privacy, which includes not to have their property searched. Property in this regard, remember Article 260 of the Constitution of Kenya classifies intellectual property as property. Therefore, even though it's data which is intangible, it is categorized as property under the Constitution of Kenya, therefore making it inherently having the right of privacy and all other rights that accrue with it, which include sharing without consent, which is a crime. Therefore, there has to be consent before your private data is shared. In addition to that, you also had Section 31, 2009 of the Kenya Information and Communications Act, which states that a licensed telecommunication operator who otherwise in the course of his business. When you talk of otherwise in the course of business, it means that it creates the exception that where they are doing this, they are sharing your data in the course of business, it won't be a crime. But when they disclose it to any person or the contents of the statements of accounts specifying the telecommunication services provided to you, then they'll have committed an offense. And the act goes ahead to state the sentence and fine to be paid thereof. Section 15 of the Kenya Information and Communications Act on Consumer Protection Regulations 2010 also states that subject to the provisions of the Act, a licensee shall not monitor or undertake any activity that constitutes of surveillance. So in this case, when we talk of surveillance, we should distinguish it from market data and sharing of market data, whereby when you visit a site, there's something called cookies. A cookie is the information that is stored by the website browser to help identify you the next time you get into the site. Now, with time, they collect so much data in the browser that they are able to profile you. Now, this information then about you, it becomes your own personal data in the sense that it was construed or it was accrued from you through your website activities. To some extent, this is surveillance. However, is this illegal or not? We shall see further ahead as we look at the provisions of the Data Protection Act 2019. So in the Data Protection Act 2019 outlines the provision governing the scope of the act. It states it outlines provisions such as, but not limited to, the establishment of the Office of the Data Protection Commissioner, which is the one in charge of data protection in Kenya. Also, the transfer of personal data outside Kenya and its exemptions, and the registration of data controllers and data processors. As we discuss this topic, you may think that data controllers are only the big companies such as Google and all that. But data also, being a data controller in line with the act means anyone who's accepting data and processing it for a certain specific aim. Therefore, you may own a website and have the space down there like reach out to us, whereby people are able to input their emails for them to contact you. That is data collection, which makes you a data controller. In that regard, you have, sorry?
Excuse me, Rogers, people are waiting in the lobby. Please admit them.
Oh,
please admit.
Sorry, I didn't see. Oh, poleni sana. Admit all. Okay. Oh, we are not two hosts at the same time?
No.
Oh, okay. So some of the functions of the Office of the Data Protection include establishing a register, promotion of self-regulation, conducting an assessment on its own initiative, receiving and investigating complaints regarding to data protection. Now, this is to say when someone realizes that you've breached their right to privacy by sharing their personal data, contrary to the aim. Will you help me mute that, Angie? contrary to the aim that you collected the data, they have a right to take the complaint to the data commissioner. And we have such an instance, such as the Register of Political Parties in Kenya was reported to the data commissioner for the data that he shared on people, whereby people complained they found themselves having been in the register of several political parties, yet they have never registered. Such is an example of a breach of the right to privacy in the digital space. Also in the same point, as you remember, though this was before the commencement of the Act, in 2017, it was alleged that Cambridge Analytica, which was a firm or company, we may call it, that helped Donald Trump win the elections in the States. So basically what they were doing, they were using the cookies, which I've mentioned. They were using the cookies to profile various citizens. Then after profiling them, they could categorize them as easily influenced or not easily influenced. Then afterwards, they would show them targeted marketing of information, whether negative or positive, to help influence their decision-making in the elections. And in the Cambridge Analytica, it was also alleged that they also applied this in Kenya in the 2017 elections, which they say it was very successful, allegedly. Okay, another function is to promote the international cooperation on matters relating to data protection. When we talk of international cooperation, we talk of compliance, whereby the European Union may have several policies or aid they wish to help several countries with, but the country ends up being not GDPR compliant, because by not being GDPR compliant, it shows that their data can easily be influenced or can easily be sold to other parties, as is the case with the Cambridge Analytica. And then this then makes the country unsuitable for business opportunities. Also, the last task is to perform such other functions as the Act may prescribe. Now, in the Act, the same as the GDPR, they also had principles which they outlined. These principles basically are the duties of a data collector. So you as a data collector, it may even be a questionnaire that you have given people to undertake your research. You as a data collector, what are your duties? It should be processed in accordance with the right of privacy. So you must uphold the right of privacy of the data of the person you've collected, who is the data subject, processed lawfully and fairly in a transparent manner. Also, it should be adequate, relevant, and limited to what is necessary. This is to mean if you took the data for a specific reason, let's say to conduct maybe a market research, you cannot then come again and use this data for a separate function from market research. And if you do so, the data subject has a right to sue you. Now, it should also be collected only where a valid explanation is provided whenever information relating to the family affairs or private affairs is required. So when you're collecting information of such a nature, you must explain the reason why you're collecting it.
Kindly allow me to interject. Sorry, Roger.
Yes.
I just wanted to remind you, if there are people at the lobby, please admit them. If there's
Okay.
Okay, thank you.
Okay, I will. Thanks. Also, the information should be kept in a form which identifies the data subject for longer than is kept in a form which identifies the data subjects for no longer than is necessary for the purpose which is collected. So therefore, this sets a time frame to which the data should be maintained. You can collect data for a specific purpose, and once the purpose is complete, you must delete that data. So this is a principle, though not, it's a principle that guides how people should collect the data, which slightly departs from the GDPR, because the GDPR provides that when the data subject expressly states that you delete the data, you must delete it. This is what is known as the right to be forgotten. You have a right to be forgotten once your data is collected. Also, lastly, the last principle, it should not be transferred outside Kenya unless there's proof of adequate data protection safeguards or consent from the data subject. So this is to say, once the data is taken outside Kenya or is to be used outside Kenya, the data controller must ensure that they get explicit consent from the data subject. In relation to that, one thing that I noted was